President's lawyers will have a chance to make their presentation. And as we will not have the ability to respond to what they say, I want to give you a little preview of what I think they're going to have in store for you. You may hear an argument that the president was really concerned about corruption, and he was concerned about burden sharing.
Burden sharing was discussed in the call.
Nothing about the burden changed between the time he froze the aid and the time he released the aid. There was no new effort to get others to contribute more, and Europe contributes a great deal as it is. This is an after-the-fact rationalization. I expect that they will attack the process. I don't think that's any mystery.
If you were really interested in finding out the truth, why would you run a process the way they ran?
When they say the process was unfair, what they really mean is, don't look at what the president did. For God's sake, don't look at what the president did. You'll hear the president wasn't allowed to participate in the Judiciary Committee.
If you were really confident in your position on the facts, why would you lock everybody out of it from the president's side? Why would you do that?
That's false too, as you've heard. The president had the same rights in our proceedings as President Nixon and President Clinton. The second thing you'll hear from the president's team is attack the managers, especially that Schiff guy. He's the worst. He's the worst. And Exhibit A, he mocked the president as if he was shaking down the leader of another country like he was an organized crime figure.
Shorn of its rambling character and in not so many words, this is the essence of what the president communicates.
That's fake. That's not the real call.
Never mind that I said I wasn't using his words before I said it, and I wasn't using his words after I said it, and I said I was making a parody of his words. It's an outrage. You'll also hear the defense. The president said there was no quid pro quo.
The transcript shows that the president did not condition either security assistance or a meeting on anything.
This is a well-known principle of criminal law that if the defendant says he didn't do it, he couldn't have done it. If the defendant learns that he's been caught and he says he didn't do it, he couldn't have done it. That doesn't hold up in any court in the land. It shouldn't hold up here. And they will also make the argument, Ukraine thinks the call was perfect. Ukraine says there was no pressure.
President Zelensky and other Ukrainian officials have repeatedly said that there was no quid pro quo and no pressure on them to review anything.
What that really means is Ukraine wants a future. Ukraine knows it's still beholden to us for aid. Ukraine still hasn't gotten in through the door of the White House. Ukraine knows that if they acknowledge that they were shaken down by the President of the United States, the President of the United States will make them pay. You also hear a variation of the argument, no harm, no foul.
President Zelensky and high-ranking Ukrainian officials did not even know the security assistance was paused until the end of August.
The moment Russia found out about this, and I have to imagine, given how good their intel services are, they did not have to wait for Politico to break the story any more than Ukraine did. The moment Ukraine learned and Russia learned, there was harm. Because Ukraine knew they couldn't trust us. Russia knew they could take advantage of us. There was immediate harm. And because someone is caught, because a scheme is thwarted, doesn't make that scheme any less criminal and corrupt. You get no pass when you get caught. Now, I expect one of the defenses you'll see is they will play you certain testimony from the House, where my colleagues on the other side of the aisle ask questions like, did the president ever say he was bribing Ukraine? Did you ever see him actually bribe Ukraine? Did you hear him say that he was going to bribe Ukraine? Did you personally see this yourself. And if you didn't see it, if he didn't lay it out for you, then it couldn't have happened.
Not a single witness testified that the president himself said that there was any connection between any investigations and security assistance, a presidential meeting, or anything else.
2 + 2 does not equal 4. You are not allowed to consider anything except for a televised confession by the president. And even then, don't consider it. You also hear a variation of the argument, no harm, no foul. They got the money. They got the money. And they got the meeting even though they didn't.
The security assistance flowed on September 11, and a presidential meeting took place on September 25, without the Ukrainian government announcing any investigations.
No harm, no foul, right? A meeting on the sidelines is pretty much the same thing, right, as a head of state meeting in the Oval Office? Of course it's not. Why do you think at that meeting at the United Nations, the president of Ukraine was still saying, hey, when am I going to get to come to town? He certainly recognizes the difference, and we should too. So what do all these defenses mean?
Each one of these 6 facts, standing alone, is enough to sink the Democrats' case. Combined, they establish what we've known since the beginning. The president did absolutely nothing wrong.
What they mean is, under Article 2, the president can do whatever he wants. That's really it. That's really it, stripped of all the detail and all the histrionics. What they want us to believe is the president can do whatever he wants under Article 2, and there is nothing that you or the House can do about it.